Well, hello. This is Charles Lincoln. I haven't done a talk in a while, so I thought I'd bring everybody up to date on some of the trivia behind Sines v. Kessler that maybe the mainstream press doesn't find newsworthy or interesting to talk about. I find everything in the law interesting to talk about, of course. And so I just realized I never do a show without shaving, and I guess I messed up here. But it doesn't matter because this is a late night show on Veterans Day, Remembrance Day. I don't have a poppy. I should have a poppy. But anyhow, it is a great day to look back on the first 2 weeks or so of the Sines v. Kessler trial and the amazing things that are going on. First off, I wanted to congratulate the person I think is really the star of this show, even though he's a pro se litigant. Courts hate pro se litigants. They treat them like dirt. And so it's kind of amazing that beyond reasonable doubt, Chris Cantwell is the undisputed star of the Sines v. Kessler trial in Charlottesville, Virginia, Western District of Virginia, a court that probably not many people thought about until just recently, but it is an amazing place and some very important stuff is going on there. I want to share with you the latest finding by Mr. Cantwell, which I think is pretty interesting. Let's see, here it is. Yes, share. Always forget how to do this. He's writing this as an incarcerated person, and I guess he's just had a lot of time to learn good legal argument and style because he's doing really well. He's very effective in court. He asks the best questions. He really zeroes in on topics of interest. He's outstanding. Dear Judge Moon, this is all public record, even though it's handwritten, by the way, so that's how I happen to have it. Dear Judge Moon, I write to you on this 9th evening of November 2021, I guess that's 24 hours ago, in opposition to plaintiff's November 8th letter, seeking to show the jury inadmissible evidence labeled PX 2777. Even under the guise of expert testimony, this saboteur's hearsay ought not to be shown to the jury. While it is true that experts may testify to opinions formed from hearsay, it is quite a different matter to use an alleged expert to expose the jury to evidence directly. The Blee and Siri report is largely borderline plagiarism from the Southern Law Poverty Letter Center's website as it is. The SPLC is a partisan Democrat outfit which deals in accusations of various types of extremism to the political benefit of their paymasters. This court would not and should not allow the plaintiffs to print out smear pieces on the defendants from that website and hand them out to the jury just because they found an alleged academic to comment on it. The author of this blog post at issue here is every bit as adverse to the plaintiffs as every bit as adverse to the defendants, I guess, as the SPLC. The plaintiffs referenced this blog post in their second amended complaint, but conspicuously chose not to name the author. Even now, they are playing dumb by only referring to him as, I can't read that, Weave, which is obviously an alias. The author's real name is Andrew Ohrenheimer, and it's no secret that Mr. Ohrenheimer hails from Jewish ancestry. As long as we are exposing the jury to hearsay from Mr. Ohrenheimer, we should probably introduce screenshots of him saying so repeatedly. Ohrenheimer describes himself as a troll. He really does. Wow. And he has stated that his involvement in the so-called white supremacist movement is an elaborate hoax designed to discredit the people he associates himself with. The blog post in question fits this profile perfectly. The plaintiffs couldn't come up with more convenient propaganda if they wrote and planted it themselves, which if they wrote and planted it themselves, which without the capacity to cross-examine the author and publisher, they very well might have, for all we know. To tarnish the remaining defendants with this material, plaintiffs cite two posts on Discord, one by defendant Ray, who has abandoned this litigation and incurred adverse inference as a result. The other is by RCO Nick Tix 8823, who is not identified. The Ray post is made in a Discord server named Osmodor, and there is no indication that it was ever seen by any defendant. The pseudonymous, I think that's misspelled, pseudonymous, the guy with a pseudonym, RCO Nick Tex post does appear in the Charlottesville Discord leadership discussion channel, but there is no similar indication anyone ever read it or interacted with this functionally anonymous post. The prejudice of this material against the remaining defendants clearly outweighs any probative value, and that is obviously the whole point. The plaintiffs are seeking to introduce adverse inferences without going through the trouble of asking the court to approach them. This effort was well on display with the plaintiff's questioning of Mr. Parrott today, and adjacently in their tedious impeachment efforts against him and Mr. Spencer. The plaintiffs hope to fill the giant glaring holes in their paranoid fictional conspiracy theory with warrantless suspicion and incitement of racial tensions with the jury. Cross-examining Mr. Simi does not offer any meaningful opportunity to remedy the prejudice this is clearly designed to impose. Simi is in no position to comment on the Jewish author's mindset. At the time of publication, or at the time he decided to sabotage the so-called white supremacist movement. Doubtless, Mr. Simi would deny any knowledge of Mr. Ohrenheimer's ancestry or his admissions of infiltrations and sabotage. Beyond Ohrenheimer's own nefarious dealings, the Daily Stormer and Andrew Anglin are themselves adverse parties to the remaining plaintiffs. In my case, I have been relentlessly smeared as a rat by the Daily Stormer for cooperating with the FBI investigation into the events and discovery in this case. If the court permits the hearsay of RXPX 2777, will it also permit me to introduce the relentless stream of smear campaigns the Daily Stormer has unleashed on cooperating defendants? I know the answer to that one, by the way. No. If so, that might cure the prejudice, but it would also defeat the point. He's got a point there. Sim's testimony is suspect in its own right, and it should not become a vehicle for hearsay from adverse, unaccountable non-parties. For the foregoing reasons, the court should exclude any reference to PX 2777 from Tim's testimony, and certainly should not show it to the jury. To whatever extent this evidence is admitted, so should the evidence of the Daily Stormers' hostility towards the remaining defendants. Respectfully submitted, Christopher Cantwell, 11/9/2021. That's day before yesterday. Anyhow, Chris Cantwell, I have never met you. I don't know that I ever will meet you, but I really congratulate you on a very well-written motion. Although I don't think this business about the Daily Stormer will help the cause particularly. Anyhow, that's interesting only in part because there's a little green-eyed idol to the north of Kathmandu. No. Because there is an order on file in this case from April 15th, 2021, about expert witnesses entered by Judge Norman K. Moon. This opinion, I wish I could imitate his accent. I wish I had a beautiful Southern accent like he does. My whole family did, but somehow I guess I didn't get it. This opinion principally addresses whether plaintiffs' experts, two sociologists who study white supremacy in the United States, can testify to a jury that groups in the white supremacist movement have developed and often employ doublespeak or just joking strategies which afford its adherents plausible deniability when conveying certain racist or violent images. As plaintiffs' experts describe it, outsiders would only hear an innocuous comment or think the speaker was making a tasteless joke, while those in the know would understand the hidden meaning. Plaintiffs are asserting that defendants are individuals and groups that organized and conspired to commit racial violence at the Unite the Right rally held in Charlottesville on August 11th and 12th, 2017. Plaintiffs' experts intend to testify that certain communications between defendants and online comments they made were consistent with those strategies. Defendants Jason Kessler, Nathan D'Amigo, Matthew Parrott, Identity Europa, and Traditionalist Workers' Party movement defendants have filed a motion to exclude such testimony. In their view, that type of testimony would intrude upon the jury's province to determine their credibility and would violate case law prohibiting expert testimony characterizing a fact witness as a liar. Movement experts further argue that such testimony would improperly tell the jury what result to reach. Movement defendants raise several other arguments. They challenge plaintiffs' experts' description of a white supremacist movement with common traits, including glorifying and normalizing violence. They argue that by using that phrase, plaintiffs are trying to build into expert witness testimony an improper shortcut to plaintiffs' burden to prove an actual conspiracy amongst the defendants. Movement defendants also argue that allowing this testimony would be unfairly prejudicial. The court concludes that plaintiffs' proposed expert testimony is proper. Expert testimony has long been allowed to explain the jury meaning of coded language. Plaintiffs' experts' intended testimony about doublespeak and just joking strategies are akin to coded language meant to deceive outside groups about the meaning of conversations among those seeking to engage in illegal or violent conduct. Moreover, the expert's testimony is also grounded in numerous specific examples, and it fits well within the types of specialized knowledge that courts have regularly found helpful to a jury. While movement defendants' position is not entirely without force in the abstract, on this record and considering the parties' arguments, there is little indication that the expert's testimony will stray into improper characterizations or or subjects. For these written reasons and the reasons that follow, the court has denied the motion. Defendants may later raise specific objections when the expert testify in trial. Kathleen Blay is a professor of sociology and dean of the School of Arts and Sciences and College of General Studies at the University of Pittsburgh. Blay and Simi expert report. Professor Blay specializes in social movements, including racist, anti-Semitic, and right-wing movements, racial violence, and microsociology. Microsociology. I guess very small societies like families or something. Professor Peter Simi is an associate professor in the Department of Sociology at Chapman University. He has studied extremist groups and violence for more than 20 years, conducting interviews and observation with a range of violent gangs and extremists. Plaintiffs retained Blay and Simi as expert witnesses to apply their expertise in the characteristics of the historical white supremacist movement to their examination of the materials in this case. They were retained to analyze whether defendants utilized the tools and tactics of white supremacist movement in planning and implementing the events on August 11th to 12th in 2017 in Charlottesville, Virginia. As plaintiffs' counsel describe it, Blay and Simi drew on their research and scholarship to describe a distinct white supremacist culture that throughout its lengthy history has informed the often coded language, tactics, and symbols of those who are immersed in that culture. Then, using a social science methodology, Blay and Simi compared the distinctive features of that well-defined culture to the language, tactics, and symbols of defendants leading up to Unite the Right. Based on their experience and analysis and described in their 60-plus page expert report, Blay and Simi reached the following conclusions. One, the white supremacist movement, WSM, in the United States has consistently utilized, supported, and glorified violence as a strategy to promote its message and secure white supremacy. Two, defendants were active in and knowledgeable about the culture and networks of the WSM prior to Unite the Right. Three, Unite the Right was organized to promote the agenda of the WSM. Four, to organize Unite the Right, defendant used the cultural symbols, rituals, slogans, and references to historical figures that are hallmarks of the WSM. Five, defendants shaped and made use of the WSM culture and networks to recruit participants and to plan and execute Unite the Right. And six, the coordinated race-based violence facilitated and committed by the defendants at Unite the Right is emblematic of WSM, white supremacist movement tactics. In Blay and Simi's view, defendants' conduct planning Unite the Right quite plainly followed the playbook of WSM. They further concluded that defendants utilized WSM tactics, principally the reliance on racial animus as a motivator, the intentional use of violence to achieve their goals, and a coordinated strategy to obfuscate their aims through the use of doublespeak, front stage, backstage behavior, and a discrete new age communication platform. At first, movement defendants sought to include Blay and Simi's report in its entirety and preclude them from testifying at all. However, in their reply and later at oral argument, movement defendants narrowed their position. Instead, they sought only to limit Blay and Simi's testimony in certain respects. Movement defendants' briefs offered little description of those portions of the expert testimony. Movement defendants' briefs offered little description of those portions of the expert testimony they found objectionable. Then, at oral argument, counsel for movant's defendants listed numerous excerpts from Blaze and Simi's expert he found objectionable. Although the court offered movant defendants counsel the opportunity to submit a later memorandum further articulating the bases for their objections at specific portions of the report, they never availed themselves of the opportunity. Footnotes: in addition, movants defendants had originally sought to exclude testimony from two other experts proposed by defendants. However, in their reply brief, movants defendants withdrew their objections. It would literally require a page-by-page analysis to specify each objectionable section of the report intended to rely on oral argument. The issues movant defendants do not challenge and thus are conceded for purposes of this motion are significant. For instance, they do not object to Blay and Simi's expert qualifications. Dean of College of Arts and Sciences at the University of Pittsburgh is okay. The methodology Blay and Simi employed in their conclusions or its reliability. Testimony that includes the presentation of data from the record and even some historical data that's not necessarily recorded in this case, but that puts defendants' comments and their activities into historical context, testimony about historical review of white supremacist language and similarities of defendants' rhetoric and processes with those historical examples. Testimony using defendants' own words and showing how it ties in with some of these groups that they are talking about in the past. Neither do nor can movants defendants dispute that courts have long found admissible expert testimony that explains the meaning of coded language to a jury. While counsel for movant defendants initially argued for a distinction between admitting such testimony in the drug trafficking context, counsel agreed that doublespeak is not unique to drug trafficking, but is commonplace in all situations. The judge's order in this case, in this matter, is 26 pages long, and I really don't think I'm going to read the whole thing. I may skim through it and see if I see anything that we need to read here. Notwithstanding such concessions, movant defendants have raised several arguments to limit Blay's and Simi's anticipated testimony. First, movant defendants challenge Blay's and Simi's anticipated testimony that groups in the white supremacist movement engage in doublespeak, just joking, or front stage, backstage strategies, as well as their testimony that a defendant's or witnesses' communications in this case are consistent with such strategies. Second, movant defendants challenge Blay and Simi's use of the term white supremacist movement, as well as certain testimony regarding the core characteristics of groups within that movement. Third, movant defendants argue that Blay and Simi's testimony are improperly attempts to opine on witness credibility, as well as on an ultimate issue in dispute. You know, so I guess this is actually precisely the same person that Simi, okay, Simi, yes, I didn't realize it at first. This is precisely the same person that Cantwell is talking about. And it shows that the judge does find this expert testimony, which I believe is going to be introduced tomorrow and possibly the last day of plaintiff's case, after which I hope the defendants, especially League of the South and Michael Hill, will move for directed verdict. I hope they've already got that sitting ready. They're ready. They have a motion. They had a motion for summary judgment. When was it filed? August 7th, 2020. They had a motion which was denied, basically with the permission to raise it again at the Unite the Right rally. I think that the League of the South and Michael Hill and Michael Tubbs are totally entitled to directed verdict as of tomorrow. the only real violence at Unite the Right was James Field, and I think they hit the nose on the nail. They hit the nail on the head. I'm getting tired. James Field acted alone. There is insufficient evidence that he conspired with any of the defendants to commit racial violence. The torch march was planned and executed without the involvement of Hill, Tubbs, or the League of the South. Indeed, when I asked by email several hours later whether the League was participating in the torch march, Hill responded, "This is not our game. We are sending two observers." All of the plaintiff's injuries resulted either from the torch march or the Fields car attack. Because Fields was not a co-conspirator with any of the defendants in this lawsuit, and because the movement defendants did not participate in any manner with the planning or execution of the torch march, counts 1, 2, and 3 of the Second Amendment complaint should be dismissed as to the movement defendants. That's not the proper plea at an end for a motion for summary judgment. You should say that the defendants are entitled to judgment as a matter of law. This is federal court, not some silly state court. You don't defend cases on them. You don't dismiss cases on a motion for summary judgment. You get final judgment as a matter of law in your favor. Anyhow, civil procedure lesson for the day now completed. Rule 56 of the Federal Rules of Civil Procedure. Anyhow, that's all fine and dandy, but we've got to read one more thing from today's record. It's all tomorrow. The final day of the plaintiff's case is going to be all about these expert witnesses. There was a motion that was denied on, when was this denied? Please go that way. I'd be happy to give you more details if you're interested, because I'm very interested in everything to do with the treatment of language in the law, because law is pure language. Entered this 15th day of April, God, 6.5 months ago, 7 months ago. I'll read his conclusion, of course. The court has already described how Blay and Simi's testimony regarding the meaning of coded or obscure language and symbols, testimony regarding white supremacist groups' use of doublespeak, just joking, or front stage, backstage strategies are admissible. If Blay and Simi seek to testify applying their social science methodology to describe those strategies, and further to opine on whether certain of defendants' communications were consistent with those strategies, assuming proper context is given and the defendants have the opportunity to test those interpretations and offer contrary evidence, that testimony is admissible. That is not improperly weighing in on any defendant's or witness's credibility, which is the jury's sole purview. It is offering an interpretation of their language based on specialized knowledge and tested methodology. The fact that any defendant, witness, or witness may have a different explanation from the experts does not make the expert testimony improper. Moreover, this case is far afield of the cases upon which movement defendants rely for their credibility argument. See United States v. Cecil, 1988. Holding that opinion of the credibility of a witness by a psychiatrist is not allowable. In any event, plaintiff's counsel acknowledged that their experts will not opine on any defendant or witness's credibility, and that they absolutely are not going to say that any witness is lying. Plaintiff's counsel also clearly stated that their experts will not opine on whether there is a conspiracy, and that they will not opine on what any particular defendant intended, and that they will not state any sort of legal conclusion. For these reasons, and with those limitations in mind, acknowledged by plaintiff's counsel, the court rejects movement defendants' arguments that Blay and Simi should be precluded from testifying on their testimony or their testimony limited because it would improperly weigh on the witness credibility or state a legal conclusion. The court will allow plaintiffs to offer Blay and Simi's proffered expert testimony within the limits discussed above. That the court will allow plaintiffs to offer Blay and Simi's proffered expert testimony within the limits discussed above does not mean it will be presented to the jury unassailable and unchallenged. As safeguards upon the introduction of this, as with any other expert testimony, defendants shall certainly be afforded the traditional and appropriate means of challenging expert witness testimony, including by vigorous cross-examination, presentation of contrary evidence, and careful instruction on the burden of proof. Daubert. Daubert is the big civil. Daubert v. Merrill Dow is a 1990s case, the key case on expert witnesses, along with one romantically entitled Cum Ho Tires in the United States Supreme Court. Daubert v. Merrill Dow and Cum Ho Tires. Yeah, who could ever forget Cum Ho Tires? Anyhow, at a later date and after soliciting input from the parties, the court intends to give detailed instructions to the jury about how it is to consider expert testimony, including that it is the jury's role to determine the weight afforded to each expert's testimony, and that the jury are the sole judges of the credibility of witnesses and the weight their testimony deserves for all witnesses, both fact and expert. Because the court has found no basis in movement defendants' arguments to preclude or limit Blay and Simi's proffered expert testimony, the court has denied their motion to exclude. This does not preclude defendants from later raising specific objections in the court of the expert testimony. The clerk of court is directed to send a copy of this memorandum opinion to the parties. Norman K. Moon, Senior United States District Judge. I like him. I think he's basically been okay. I don't see that he's been at all. I think he's been, at least of what I've heard of the trial, he's been pretty good. You know, I should do a special talk on the use of linguistic experts. There's a case involving Hillary Clinton, her nomination for Secretary of State, that's worth a lot more attention than it gets based on linguistic testimony. The Clinton family really, you know, Bill is famous for his challenges to what's the meaning of is, as in was it sex? Anyhow, let's see here. I did want to read you something else. Let me see if I can find it. Where is it? Yeah, I guess it's right here, isn't it? Are you looking at this still? Are you looking at the screen? We've now got the docket of Sines v. Kessler as of November 10th, 11:01 p.m. Tomorrow's 11th day of the 11th month, and we'll have two 11:11 hours. But what I really wanted you to read you from November 10th, let's see if I can find it again. That's the list of lawyers we're going through. List of lawyers takes how many pages? The list of lawyers in this case, list of signing lawyers, never mind all the people who work in the background. The list of signing lawyers in this case is, it's over 50 pages, yeah. 51, 52, 53, 54, 55, 57. At page 58, we finally get to November the 10th. I always organize these things from most recent to oldest. Docket is up to 14 1491 at the beginning of the case. What was it? At the beginning of the case, at trial, I mean, at the beginning of trial, at the beginning of trial on, when was it, Thanksgiving or not? Not Thanksgiving. Thanksgiving is 2 weeks. At the beginning of a docket, I thought I got it somewhere, a civil docket on the eve of trial on October 27th. The list of lawyers was just as long, of course, but on October the 27th, the docket sheet on all pretrial matters was up to 345 entries. And as of today, it's, I guess it's only gotten 100 more docket entries, 1419. Anyhow, the last thing I want to read you tonight is rather interesting, long-winded thing about, well, not long-winded, it's pretty short compared to the judge's oral order. This matter is before the court on a letter filed by Joshua Smith, Esquire, counsel of record for defendants Matthew Heimbach, David Matthew Parrott, Traditionalist Workers Party. Mr. Smith seeks monetary sanctions against plaintiff's counsel for allegedly violating my settlement conference order, directing the parties and their lead counsel to appear before me via video conference on August 20th, 2021, for the purpose of conducting discussions in good faith towards a compromise resolution of this case. ECF number 989, 500 entries ago. This order contained my standard language cautioning all parties and attorneys that if a party fails to negotiate in good faith at the, did I skip something? Fails to negotiate in good faith. This order contained my standard language cautioning all parties and attorneys that if a party fails to negotiate in good faith at the settlement conference, then I may assess against the non-complying party, attorney, or both a monetary sanction, which may include the fees and expenses incurred by the other parties in attending the conference, in attending the settlement conference. In support of his request for monetary sanctions, Mr. Smith cites a recent National Law Journal article in which plaintiff's counsel, Michael Block, Esquire, recalled discussing this litigation with co-counsel Roberta Kaplan, Esquire, while she was interviewing her law firm in late 2018. Mr. Block asked Ms. Kaplan whether she was confident the case was going to trial and wouldn't settle. He recalled that Ms. Kaplan responded with a powerful look and was like, "We don't settle with Nazis. We don't settle with Nazis." Mr. Block has been one of plaintiff's lead attorneys since February 6, 2019. A request for a court order must be made by motion and not by letter or other paper. Well, that varies by case, by state, believe it or not. In New Jersey, for instance, I happen to know that all the courts require letters, and some of the California courts require letters before you file because they'd rather have an informal letter than a formal motion. A request for an order must be made by motion. Federal Rule of Civil Procedure 7, and not by letter or other paper. Western District of Virginia Civil Rule. So Western District of Virginia is different from District of New Jersey or some divisions of the Southern District of California, for instance, Central and Southern. Accordingly, Mr. Smith's request is improper and could be denied on those procedural grounds alone. On the merits, Ms. Kaplan's comment to Mr. Block during a job interview in late 2018 preceded the settlement conference by nearly 3 years, which is too remote to have any to establish any ill intent. More importantly, plaintiff's counsel spent considerable time negotiating with opposing counsel and made good faith efforts to resolve the matters at issue both before and during the day-long settlement conference on August 20th, 2021. Nothing during the settlement conference or in the period leading up to it suggests that plaintiff's counsel violated the court's order. Accordingly, Mr. Smith's requested relief, ECF 1395, is denied. Oh, that was before the magistrate. That wasn't before Judge Moon. I guess that's why it wasn't part of the proceedings. Of course, they had the opportunity to object to it to the judge. But anyhow, I don't know. I've listened, I should say. I'm not in Charlottesville, so I haven't watched it. But I've listened in on substantial portions of the testimony. I think that beyond any reasonable doubt, Michael Hill and Michael Tubbs have been the star witnesses for the defendants. Although Chris Cantwell has been the star attorney, certainly was one of the best pro se litigants I have seen in a very long time. I hate to admit this, but he's probably as good or better than I am as a pro se litigant. So, Mr. Cantwell, you're doing good. My best regards and best wishes for motions for directed verdict on behalf of all defendants, not tomorrow, but I guess Friday. I hope that they're all just preparing. They're taking tomorrow to prepare. Today rather is Armistice Day, Remembrance Day. I misplaced my puppy. I mentioned that, but anyhow, happy Veterans Day to all who are veterans, and my thank you for your service. People like me who are not in good shape just can't do it. But anyhow, happy Veterans Day, and I will be talking to you all very soon again. Gotta figure out how to get this stopped now. I have to stop sharing first. That's what I have to do. Okay, yeah, stop sharing the screen. You get to see my unshaved face one more time before I sign off. This is what happens when there's no lady in the house, I tell you. Clarice come back from Florida. What can I say? Good night, everybody. Happy Veterans Day.